Hi, it's Marlene Ebinger. Welcome to Legal Professional Conduct. We're going to start now with week one, topic one, accountability and responsibility. You would have hopefully saw my welcome video, and you'll know that I'm both a solicitor and accredited family law specialist and have worked in academia for a number of years. So let's get into this unit. The book that you need to have is Isaiah Ross, Ethics in Law, Lawyers' Responsibility and Accountability. Hopefully you've got that, because you will need to be doing some reading within that. On this slide, you'll see what the objectives of this unit are, and it's really about looking at the law as a profession, how you're going to locate and critique the sources of the legal ethics governing the profession in Queensland, because that's our focus, Queensland. But you'll note that they're fairly similar across the country. Discuss the major themes of contemporary debates about legal ethics and professional responsibility, and articulate a variety of approaches to questions of legal ethics and professional responsibility. So some of the things that you're going to look at, why is this really important to you? So a lot of students think that ethics is a theoretical subject with no practical application. Well, they say, why should I study this course at all, and find justification for devoting as little effort as possible to the subject, with the view that ethics is not a practice area from which practitioners make money. Well, it's really not a practice area, but it is a unit that you will find to be the most important in your career as a lawyer. So we're going to look at just some examples. So you can see here, a lucrative client for the firm asks you to backdate a document. No one will ever know. Can you do that? This is what you're going to start thinking about with this unit, whether you can or cannot do that. Here you've got a wife of your happily married and trusting client who asks for details of her husband's company. Need to think about, is she entitled to this confidential information? Why is she asking for that information? Do you need to ask the husband for his consent to give her that information? Your client sends you a statutory declaration to urgently witness to get a very important case over the line, but it's actually already been signed by the declarant. Can you again witness this signature, which has already been made and not in your presence? And if you do that, what are the consequences of doing that? So dealing with these issues is much easier when you have a strong awareness of your ethical obligations as a legal practitioner. And again, considering financial issues again, you can save thousands of dollars and ultimately your career if you master legal ethics and professional conduct. When you run into an ethical problem in practice, which you will on many occasions, your response will determine your fate. Make the wrong decision and you may find yourself with a charge of professional misconduct or unprofessional conduct. Now, the penalties start from reprimands to fines to paying legal services commissioners' costs to ultimately being struck off the roll of legal practitioners, something you certainly don't want to find yourself doing. So let's ask them, what are ethics? Well, the word ethics derives from the Greek ethos and ethikos, the former meaning character and the latter meaning practice or custom of the community. Aristotle defined ethos in a rhetoric as being the trustworthiness or credibility of the speaker. The modern definition is the science of morals or rules of conduct or values and rules of individuals. Professional ethics are the values and rules of conduct of an occupational group, which is in our case the legal profession. So again, you'll find this all in your textbook, which I encourage you to read. So if we look at morals, values, beliefs and conventions, so these are principles inserted within that concept of ethics and how we interact with others in the profession. So morals derives again from the Latin word word mores, meaning custom or conventions of a social group, and the modern meaning includes distinguishing between right and wrong. Values are principles or qualities which we consider worthy or desirable. Beliefs are acceptance of an idea or a statement of fact as being true. And conventions are unwritten rules and practices governing the behaviour of a social or professional group. Our focus in this course will be on the ethical practicalities of professional legal practice. So let's think about how lawyers are perceived. I'm sure you've heard many, many jokes about lawyers. So really, what does the public think about lawyers? The public hate lawyers. They love to hate lawyers. And why is that the case? Because they think about the costs, the delays, the times involved, the perception of snobbery. There's no doubt that lawyers have an image problem, but it's not all negative. Perhaps, you know, for one of our tutorials, you can maybe have a look and come up with a lawyer joke so we can all have a laugh together. So, wait, I'm recording this. Okay, working from home is always interesting with interruptions, so apologies for that. So let's have a look at what are some of the positives. So rather than dwell on the stereotypes that depict lawyers as villains out to protect their own interests and line their own pockets, we should perhaps focus on the positives of the profession, which include defending the rights of those who are unable to defend themselves, pursuing just causes, I should say, unsung heroes, working completely for ordinary clients, paying modest fees, doing legal aid work, protecting civil liberties and human rights, supporting the functioning of modern society under the rule of law, and again, as I said, donating services to the public, doing pro bono work. Around 1.7 million hours of pro bono work are done every year. And so that's, you know, very important work that lawyers do. So we should be mindful of that. And I'm sure some of you are volunteering in community legal centres, and I would hope that when you do become lawyers that you continue to provide that, you know, some benefit back to the community with your skills that you're going to be gaining as a lawyer. It's really important to do that. So let's look at the size of the profession. You can see some numbers there. This was actually a while ago. I probably need to update these slides because this was back down in 2008. So I dare say it's much more than that, but you can see the numbers there and the number of people employed and the income. So we're really heavily engaged. And I want you to think about, you know, that you don't just become a solicitor or a barrister. A lot of people work in-house as lawyers in big corporations, in government, government lawyers, councils. Many people go and work as judges associates once they've finished their law degree. Great way to get experience. So people, you know, many politicians have got law degrees and have been lawyers. Many journalists as well. So they're skills that you can use across professions. So in terms of legal education, to be admitted as a lawyer in Australia, you must complete a course in professional responsibility and legal ethics. And really, it's just the start, because you're going to do this every year. While you want to hold a practicing certificate, you must obtain professional development in ethics. So they're really preparing you for practice and, you know, constantly looking at and thinking about things that arise in your life and as a professional lawyer. So while there's research to support the notion that you can learn ethical values later in life, many people believe ethical values are shaped much earlier in life as a reflection of community values and your upbringing. So really the basics, what's right and what's wrong. So whichever view is correct, it's important for you professionally to recognise ethical dilemmas and adapt strategies to solve the issues before they challenge your continued status in the profession. And this may be perceived as a form of risk management, if not a form of insurance against the disciplinary minefield of practice. You're going to soon discover that the rules of professional responsibility do not cover the field. They're there as a guide, but we don't live in a vacuum. You will at times have to resort to more general ethical principles to deal with problems that you're going to encounter. So there's a good illustration of this in the Radio National transcript that's printed in your notes concerning the life of a criminal lawyer. So if you want to have a look at that transcript, you can do so. Alrighty. So there's theories of ethics, so realism, ethical relativism, virtue, self-realization, theological, deontological approaches, lawyers and ethical theories, the trade approach, resource of power theory. And all of these you can find in your textbook. So it would be good for you to take the time to read the short summary of each of those approaches. And again, we might discuss those in the tutorials. So here's a quick slide. So moral philosophies has two broad approaches to moral issues, which might be depicted diagrammatically, the theological approach and the deontological approach. So you can see the first one, the teleological approach, is a branch of philosophy that deals with the ends or final causes. It's a theory that certain phenomena or acts are to be explained in terms of purpose or intention. It manifests in act altruism, where the behaviour chosen in a particular situation leads to the greatest good for the greatest number of people. So under the Act, utilitarianism approach is its decision is utilitarianism. So again, go to your text and read the decision. The utilitarianism is unique to the law and revolves around the court deciding the question of how the public welfare will be affected for the good rather than what is in the best for the individual parties in the case. Of course, that's going to depend on which area of law you work in. So the major flaw with this is that it tries to achieve happiness and well-being, which is fine provided you have a homogenous culture. Multiculturalism presents a major challenge, as what one ethnic group perceives as happiness and well-being may differ from the views of another culture. Impartiality is an essential requirement for this utilitarianism. In terms of the deontological approach, that focuses on the science of duty or moral obligation. The idea is to identify principles based on natural law or good truth, which are then defined in terms of rights or duties. The emphasis is on rights. One then acts according to the laws based on those rights, whatever the outcome. So this approach leads to rule utilitarianism, where one chooses behaviour from a group of similar situations that leads to the greatest good for the number of people. So have a look at an example, thou shalt not kill. That is a God-given truth. So there's no right to kill. Laws in relation to murder are then based on the absence of that right. There will be a set of circumstances in relation to murder from which behaviour is chosen that leads to the greatest good for the greatest number of people. In other words, laws and enforcement procedures are out in place to prevent murder for the benefit of the public. So how does this all apply to lawyers? Again, go back to your textbook and look at lawyers and ethical theories issues such as a moral lawyer, a lawyer as a friend, the lawyer-client relationship, workplace environments, lawyer-client dynamics, and then theological dimension. So make sure you read and praise this particular document. You need to have a look at that. So then we'll go to professionalism, the trade approach, and the power and resource theory. So lawyers are members of a profession, but again, what does that mean? Professions are associated with privilege, power, status, money, exclusion of non-members. And there are two approaches, the trade approach and the resource theory. So in terms of the trade approach, G.M. Millison talked about this in the Qualifying Associations, a Study of Professionalism, 1964. There was a meta-study which identified 6 elements that distinguished a profession from other occupations. They were skill-based on theoretical knowledge, the provision of training and education, testing the competence of members, organisation, an ethical code of conduct, and altruistic service. There are flaws in the approach. For example, the traits are in flux and vary over time. The traits can also apply to other occupations. For example, professional thieves. Okay, what we need to be really careful about is certification can be problematic. For example, in this case, Degree Mills and the Case of the Cat, Oliver Greenhall, that has a bit of a typo in that name. It's certified as a fellow of the English Association of Estate Agents and Valuers mentioned in your textbook. The owner described him on the application as a rodent operative. For example, a list of cats with fraudulent diplomas. You can see those. There are plenty of other animals with qualifications as well. Now, if you hold yourself out to be a lawyer and you're not a lawyer and you don't hold a practicing certificate, there's a penalty up to 2 years imprisonment. You cannot say that you are a lawyer without a practicing certificate, so be very careful. Power and resource theory. The issues with the trade approach led sociologists to the power and resource theory. Here the focus is on how a profession achieved their economic power and control over the market for their services, including clients and the area of expertise. This market control can lead to amassing power and monopoly rights, forcing clients to become dependent. In our society, solicitors often work for large organisations, partnerships, government, with many members of the profession being employees. This is resulting in even more centralisation of powers in the hands of a few. Barristers, in contrast, work as individuals, though are represented as a group by their respective bar associations. A good example of the monopoly is the work of conveyancers. The monopoly remains in Queensland, but has been removed in Victoria. There was no crisis in Victoria when the monopoly of lawyers was abolished, which questions why lawyers have this privilege to monopoly practice in Queensland. So anyone can be a conveyancer in Victoria. Now you do need to go off and do a course and get a qualification. Previously you didn't. You could just say, I'm a conveyancer. Economic downturns also ripple through markets for legal services, leading to price cutting and competition. Large consumers of legal service start to widen their panel of law firm providers to get the best deal. Perhaps the next major ripple will be low-cost electronic automated services delivered on the internet, which if you have a look, that's actually already happening now. So let's come down to what we're governed by, the codes of conduct, professional conduct. The primary professional codes for Queensland solicitors and barristers are going to be found in the Bar Association of Queensland Barristers Conduct Rules, the Australian Solicitors Conduct Rules, which most states now follow, Legal Profession Act of Queensland, and the Legal Profession Regulation of Queensland. So you're going to become very familiar with these over the course this semester. Now, there are many major themes of contemporary debates. So we're going to change in tact and briefly consider 5 of those contemporary debates in the Queensland legal profession. The first being access to justice. This is disadvantaged groups, including women, children, prisoners, ethnic minorities who have difficulty accessing the justice system. Government at several levels are pruning back the development of remedies, for example, limitations on personal injury insurance claims. There is inconsistency between the tax deductibility of litigation for corporations compared with non-deductibility for individuals. And in contrast, pursuit of unpopular causes is sanctioned by what we call the barristers' cab rank rule. Now, the cab rank rule is if a solicitor goes to a barrister and says, I've got this matter for you, the barrister needs to take that. Can't say, I can't do it, I don't want to do it. Unless there's conflicts, of course. Ethical rules as a form of protection, protectionism and self-interest. So the rules may be seen as supporting a cartel of legal services bolstered by a self-regulated professional code. This approach may be seen as an attempt to strengthen the position of the profession against the public interest. Balancing the public interest with that of the court. Legal professional privilege and the duty of confidentiality can cloak such activities as money laundering and destruction of disclosable documents in future litigation. Of course, destroying evidence generally may not achieve the desired result, and in contrast, costs can be made against solicitors who breach rules of court. Always remember you're an officer of the court first. And breaching rules of the court can be much more than just getting a costs order. It could mean you lose your practicing certificate and ultimately your profession. And reputation. Adequacy of professional indemnity insurance. It's no secret that Australia is in the grips of professional indemnity insurance crisis affecting many professions. Premiums have reached unprecedented levels. And you'll find out when you become a lawyer that you have to be insured. You have to have professional indemnity insurance. Whilst employed, that's paid by your employer. Once you become a principal of a firm, if that's what you achieve to do, you'll note that it's very expensive. Just in my own practice, I'm paying about $11,000 a year just for that professional indemnity insurance. Now, national admission rules and the development of code of ethics. They were set up for the implementation through the Standing Committee of the Attorney General's SCAG group, but they only gained traction in New South Wales and Victoria. So we want to have a national profession, but really only 2 states have signed up to that. And like codes of ethics, national admission rules are educative and they mould future practitioners nationwide. So that's bringing us to the end of topic 1. You've got to go away and do some reading to accompany that, and then we'll meet and have our tute. So I want you to have a look at this unit, accountability and responsibility. And next time when we get together, we're going to look at the history and structure and regulation of our profession. So hopefully you found that of some interest, and I look forward to discussing this with you when we meet online. See you later. Bye.